Thank you for clicking this video. This is Batok with Ola. My name is Mujola Oluwa, and today I want to talk about spousal maintenance or alimony in Nigeria. Recently, a viewer from Sierra Leone, left a comment on the channel asking us to talk about spousal maintenance and child custody, which we're going to be doing in two different videos. But this particular video is about maintenance, and it's dedicated to our dear viewer. Thank you so much for bringing that up. I'm going to be talking about spousal maintenance and child maintenance, both of them. So if you have not subscribed, this is the time for you to subscribe and turn on notifications. Alimony is the more common term for spousal maintenance, but there is no mention of alimony in the Nigerian laws regarding marriage. Alimony just means that you're maintaining or supporting the life of someone. So in the context of marriage, it means that you're supporting the life of your spouse, mostly financially, after the marriage has come to an end or there's been a judicial or legal separation. So the rationale behind this concept of alimony is to ensure that although the marriage is dissolved or you're separated, the other party does not feel, unsupported. That is, if they have especially been enjoying some type of support because of the marriage before. So for instance, maybe you got married and you're working, you're the sole provider in the home, and your wife, for instance, is a stay-at-home, wife, and they depend on you for support financially. When you divorce, the court will look at it. Can this person survive without you? No, they have no income. So they are entitled to ask the court to compel you to continue to support them as you have done in the marriage, indefinitely, if they have no ability to earn an income, or until they can earn an income and stand on their own. I've often tried to explain to parties in matrimonial disputes or child custody or child welfare disputes that what the court wants is for parties to be cushioned against the effect of the breakdown of these marital relations. So if it's a child, the court does not want you to put the child in a position where they wish that you were still married, or where they begin to regret or lament or suffer because you are no longer married to their parent, or that both parents are no longer married. And if it's spousal support, the court also looks at how will this person not feel, the adverse effect of not getting the support that they were getting before in this marriage. Let's make an order. So that's what alimony is about. And in Nigeria, it is called maintenance in the Matrimonial Causes Act. We are going to be looking at sections 69 and 70 of the Matrimonial Causes Act. Those are the sections that provide for maintenance, spousal maintenance. And that's the legal basis for this video if you want. So the court said in several cases, and the law has said, that either party can come to court to ask for spousal maintenance. There's also a misconception in Nigeria that only the wife is supported. No. If you're a man and you have been supported by your wife in the marriage, when the marriage ends and you can show to the court that you cannot support yourself and that this person can or has the ability to support you, especially financially, you come to court and ask for an order for maintenance or spousal support, and the court will grant it if it's so persuaded. So three things now. The first is that either party can come to ask for spousal support. It is not gendered. Husband can come, the wife can come. The second thing is that you must be able to prove to the court that you cannot support yourself and the other person can actually support you. So you're proving the financial capacity of the other person and your own financial incapacity. Now, the third thing is that it is at the discretion of the court. Like several things, in the instance of marriage and the Matrimonial Causes Act, it is largely at the discretion of the court. It depends on what you put before the court, to show the court that they should grant the order. If they're so persuaded, they will grant the order. So let's look at some of the factors that the court will consider in making a maintenance order. The first is the income and earning capacity of either parties. The court will look at the income, what you're making, earning capacity, what you have the ability to make. There are two different things. The court will look at it for the husband, for the wife, before making an order in favor of and against either party. The second is the financial needs and obligations of either party. So the court will look at what does this person that is asking for alimony need. and what are the obligations of this other person that is to provide it, and of this person that is asking as well. So the court will look at the needs and the financial obligations. That is, this person that's asking for it, what do they normally need money for? What do they spend on? And what are their obligations? Do they need to pay a certain fee at a certain time? Do they need to spend a certain amount, do some certain things? So the court will look at that. So the court will look at that for both parties. The third thing that the court would look at would be the standard of living enjoyed by both parties, during the pendency of the marriage. So for instance, maybe you and your wife, you used to maybe fly out to Dubai, go on holidays, eat out, do all sorts of things, enjoyment things, during the pendency of the marriage. You can come to court as the husband, or the wife can come to court and ask the court to make an order as to maintenance to ensure that they continue to enjoy that standard of living or close to it. Remember, I said that the most important consideration is that the court wants to cushion, the effect of the separation or the dissolution, the ending of the marriage. So the court can make an order asking either party to maintain the lifestyle that the other party asking for the order is accustomed to. I hope you understand. Also, the fourth thing the court may consider would be the duration of the marriage. It's important, if you've been together for so long, for instance, maybe you've been together for so long and you've had a house husband who's become, accustomed to, say, staying at home, caring for the children, looking after their house or home generally, where you have provided. The court will look at this when making an order that they have been accustomed to being provided for by you financially while they took care of their own. You cannot just toss them into the streets, onto the elements. So they must be cared for, because this is the lifestyle they've become accustomed to for so long. If it's a shorter period, it would also come into consideration when the court is making an order. It may be a 3-year-old marriage now. There are some things you cannot start claiming as become, your way of life, within 3 years. So the court might look at that, in determining if to grant the order for maintenance that you're asking for. The court will also look at the age and health of both parties. That is, as you're living each other, are you in good health? Can you go out and fend for yourself? Or are you incapacitated in a way that you need to be cared for, to be provided for? Your age, can you go start a life on your own now? Say maybe you've been a housewife. Can you go get a job now at your age? Your health status, can it afford you the opportunity, to make a living for yourself? So the court will look at that too in granting an order for maintenance. Also, the court will look at the contributions that both parties made in the marriage regarding homemaking, especially. What contributions did you bring into the marriage? Did you spend your salaries on the marriage? Did you contribute to the building of the house, the home? Did you used to maybe pay for the school fees of the children, pay for your wife's professional courses, what are the things that both of you contributed to the marriage? The court will look at that in granting an order for maintenance. And lastly, the court will look at the conduct of both parties. This is very tricky because, a party can pretend, before the court, but, during evidence giving and all things, judges know and they can tell who is pretending and who is not. And some lawyers would even coach their clients, so this is how you must look, make sure you dress this way, make sure you do this. Some people will come looking tattered, looking poor. Meanwhile, they're very rich, trying to sway the court, to believe that they are incapacitated financially, and so the other person should be commanded to provide for them. But the court will consider things on a holistic, from a holistic perspective. So it's important not to try to deceive the court, but to present things as they are, because the court is not just looking at one factor, they're looking at all these 7 factors that we've talked about, together at the same time in arriving at a decision. The court may also look at any other factor that is relevant to the case or that is peculiar to the particular case before it. Of course, spousal maintenance can be granted. An order can be made for the spousal maintenance to be paid to the spouse that wants it or that needs it weekly, could be monthly, could be biannually, as decided by the court. But you can also put forward how you want it to be paid to the court. And if the court decides so, it will be so, and if the court decides otherwise, it will be otherwise. The court may also compel a party to pay even where there's no ascertainable income. Once the court can confirm that there's an earning capacity, remember I said there are two different things. So for instance, if you're an artist, you don't make a salary, but you are in the process, maybe your song is in the works, or you're producing a movie or something, and there's expected earnings coming from that. The court can make an order based on that. It can even make an order based on what you have the ability to earn in the future. That's your earning capacity. The court can make an order based on that. Three more things to note. One, the right to spousal maintenance can be waived. A party can decide they don't need it, they don't want it, they just want to go their own way. Two is that a party can decide that this is what they want to do, for or towards the other person, that, okay, I'm offering to give you this, to pay this to you as spousal maintenance. So a party can say that or bring that forward on their own. And the third thing is that both parties can actually agree outside of the court. It could form some of the terms of settlement that they have arrived at, which would then be included in their case before the court, for the court to adopt it as part of its judgment in a proceeding for dissolution of marriage, for instance. So parties can reach an agreement, parties can waive it, and parties can put it forward on their own. Usually, the order for spousal maintenance terminates once the other party marries another person. Also, a party can come back to court to prove to the court that this person is now in a good state of life. They can now fend for themselves. That's if it's an indefinite order. So void this order because their status has changed. So once there's a change in the financial status or the marital status of either parties, the court could have made an order, from start, that once there's a change, it terminates. Or a party can come back to court to ask the court to vary the order or to terminate the order because of a change in status. Child support is another type of support which is also contained in the Matrimonial Causes Act. So a party can ask for child support and the court will grant the order. It's discretionary too, but the court will consider what's in the best interest of the child. In making an order for child support, regard is usually had or given to the particular circumstance of each child. But generally, under the Child Rights Act or Child Rights Law in Nigeria, child support is made or available for children who are below 21 years. So the court will make an order for child support for children of the marriage who are below 21 years. When I say children of the marriage, I mean all types of children, whether adopted children or biological children. So once they are legitimate children, whether legitimized before illegitimate and legitimized, or born by both parties originally or ordinarily, they are children of the marriage, and the court can make an order as to child support regarding them, given their particular circumstances. If a child is above 21 and needs child support, maybe it's a peculiar case, maybe the child is incapacitated in a way, the court can still make an order for child support, but generally it's for children under 21 years of age. That's all I want to talk to you about in this video. I will see you in my very next video, where hopefully we'll be talking about custody of children. Don't forget to subscribe to those.